Hey kiddos, here are your instructions for the SCOTUS case study project. Remember, the College Board requires that we really go over 15 different case decisions in detail. So this is how you will learn those 15 required cases. This is a group project and you can work with people in other classes. So here's some of your instructions. The rubric for this project can be found in the digital session on CTLS that is called SCOTUS Case Study Project. Let's see here. I already told you those first two things. After you research your case, and I'll post a list of them, and it'll be kind of a first come, first serve basis, in class on Monday. I'm going to expect you to teach the class about that case. Your presentation will need to be posted to YouTube, and this will be visual and audio. And your peers will have a note-taking guide that they're going to fill out as you teach. I would suggest using PowerPoint or Google Slides or even Prezi. For the first part of the project, you're going to describe the background and facts of the case, including the parties that are involved, both sides, the plaintiff and the defendant, the conflict between the two sides, and some historical or factual background of the case, what exactly happened that led to the Supreme Court. Number two, you're going to explain what the constitutional questions or issues are. What is the court being asked to decide or determine that's relative to the Constitution or the law? So if it's a law, definitely provide the title of the law. If it's a, well, yeah, they're all going to be laws. Sorry. Long day at the end of the week on Friday. Alrighty. Step 3, after you present the facts and the constitutional question to the class, I want you to kind of hypothesize how the case may be resolved. If we were in class, I would have you have your classmates guess, but since we're not, you're going to do it yourself. Then share the actual decision made by SCOTUS. For step 5, you're going to need to explain the court's reasoning behind its decision. If it's a 5-4 decision, what was the reasoning of the 5 and what was the reasoning of the 4? Your presentation should reflect you've done a very thorough analysis of the court's rationale. OYE is a great site to use, oyez.org. Why did the majority rule the way that it did? What legal theories or precedents did the opinion's author believe were relevant? There's, videos about these rulings, just search the internet, you'll find some good stuff. Also, you should be reading some of the actual opinion written by the justices. Excerpts are fine. And then be sure to include these in your presentation so your peers can shorthand that into their notes. The next component of the case study is going to require you to discuss the impact and significance of the ruling. Are there new legal standards, new laws created after this? What sort of things have been created? Was there a new amendment that followed because of this? A new social norm that followed because of this? New policies? What were the implications for and impact of the ruling on society as a whole? And since on the AP exam, you're going to have an FRQ that's devoted to a Supreme Court case where you'll compare a case that you've studied, one of these 15, with a new case that you probably won't recognize, I think that's a good idea for you to have to do this in this project. So you're going to share brief summaries, the background, when it was, what the vote was, of 2 cases that are similar to your case. It should be similar in terms of topic or in the area of law or constitutional question. So if your case involves the First Amendment, find another case that involves the First Amendment. It can be a recent decision that somewhat changed your own case. Or it could be precedent, a prior decision that led to the decision in your case. That's up to you. Lastly, you're going to need to provide at least one tool or device to your classmates that will help them remember this case. This could be in the form of a mnemonic device, meme, hashtag, or some other method. Obviously, be funny, but it should help us actually remember the case. And that will be the last slide of your presentation. I'm going to grade you on the following. The fact that it was completed on time and emailed to me, and all of these dates are going to be in the rubric, but I'm going to expect it emailed to me by October the 20th at midnight. That is a Tuesday. Sorry, I just had to look at the calendar. However, if you get it to me by Monday, I'll give you 2 bonus points. Just putting that out there. That all required components were completed. You demonstrated a thoroughness of research and understanding of the case. Your visual and audio presentation were clear. Oh, that's good. Try to avoid typos like that one. And well developed. And the delivery of the information was concise, engaging, and understandable. Obviously, the pandemic has lessened the time that we have to learn about government. We're short 2 class periods a week, essentially. So you're going to be recording these presentations, uploading them to YouTube, and I need the link by the 20th. You will have all next Friday to work on this during class, and then the entire weekend and Monday, and then I need it Tuesday night by midnight. Like I said again, if you get it to me by the 19th, then you'll get a couple bonus points. And this is a test grade, so a couple bonus points can make a big difference. Your peers are going to start watching and completing their note-taking guides starting on, oh, well, that should be starting the 21st, not the 22nd. And we'll have a quiz on them the 26th, which is a Monday, in Microsoft Forms. So we'll review these in class, and everyone will be expected to comment on their own case when we review them, so plan for that, and at least 2 other cases in our in-class review. That's going to be a participation component of your test grade. Your civil rights and liberties test using this and other information will be Friday, October the 30th. This is a look at the questions on the note-taking guide that you're going to fill out as you're watching the presentations completed by your classmates. I'll post a nice clean copy in the Supreme Court of the United States Case Project folder or digital session on CTLS. And here's my example to show you what I'm looking for. So I went ahead and took care of Marbury versus Madison from 1803. So a little background. In the election of 1800, John Adams does not get reelected. Thomas Jefferson beats him, right? So on his way out, John Adams, the Federalist, appointed a ton of people trying to fill as many slots with Federalist minded individuals as he possibly could. And since he made so many of these at the last minute, not everybody got their commission or their paperwork until after Jefferson was sworn in as a new president. And one of those individuals was William Marbury. So Marbury felt it was ridiculous. He should get his commission because the incoming Jefferson administration, which was Democratic Republican, denied it to him. In fact, James Madison, the Secretary of State, who would usually, see about getting these delivered, said, heck no. So Marbury appeals to SCOTUS and says, please force them to do this because according to the Judiciary Act of 1789, you have the power to do this. You have the power to make a government official perform a duty by issuing a writ of mandamus. The constitutional questions from Marbury versus Madison, I want you to write in here, what questions did the court have to consider? What were some options in terms of how they approached the dispute between the 2 parties? So there's John Marshall, and he's asking, what should I do? Do I need to consider the political ramifications of any ruling that we, the court, might make? After all, I don't want to have us appear weak. Now, this is going to come after you've given a lot of background information on the court case. So according to Marbury versus Madison, the constitutional questions are, 1, did Marbury have a right to his commission under law? As stated previously, Marbury was appointed to a position by John Adams right before he left office. But it was in such late hours, literally a midnight appointee, that the commission never made it to him. And so does Marbury have a right to that commission? Question 2, if so, does the Supreme Court have the authority to deliver the commission, order the delivery of it, by issuing a writ of mandamus? And this was established or included in the Judiciary Act of 1789 that they did have that power. Not in Article 3, though, but in later congressional legislation. Here is where I want you to throw out what some possible outcomes could be. So before revealing what the court's outcome was, I think that maybe Marbury got the job and the Secretary of State, James Madison, lost. Or maybe SCOTUS inserted themselves in a political process of filling vacancies, setting up the precedent that they'll do that in the future. Or maybe Marbury didn't get the job, and SCOTUS told the Senate, you can't tell us what to do. The applicable law here come from Article 3, Section 2, Clause 2 of the U.S. Constitution, which reads, in all cases affecting ambassadors, other public ministers and councils, and those in which the state shall be a party, the Supreme Court shall have original jurisdiction. In other words, this involves a federal employee at a high level, a council, so the Supreme Court has to hear the case and not a state court. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, yada, yada, yada. Don't worry about that part for this case. Also, the Judiciary Act of 1789 is involved here. This act authorizes the Supreme Court to issue writs of mandamus to persons holding office under the authority of the United States, which in other words is a way of telling a person to do something. In this case, it was instructing James Madison to give William Marbury his commission, his position, as appointed by outgoing President John Adams. The decision of the court was unanimous. It was 4-0. 2 people abstained because they missed oral arguments due to health reasons. And here's what the court decided. In question 1, does Marbury have a right to his commission under the law? Yes, he was entitled to his commission. Question 2, does the Supreme Court have the authority to order delivery of the commission by issuing a writ of mandamus to Secretary of State James Madison? No, they do not. The Supreme Court said that Congress overstepped their authority in the Judiciary Act of 1789 when it changed the court's original jurisdiction to include cases in which the court is being asked to issue a writ of mandamus. In other words, that part of the Judiciary Act is unconstitutional. The Supreme Court doesn't have to do that. Their reasoning came from Article 3, which clearly defines the scope of the court's original jurisdiction. It did not include issuance of a writ of mandamus. Also, the Constitution is the highest court of the land. So if you come up with a law that is conflicting with that, then that law is invalid. Certainly, all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation. And consequently, the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. It is emphatically the province and duty of the judicial department to say what the law is. Judicial review. Those who apply the rule to the particular case must, of necessity, expound and interpret that rule. If the laws conflict with each other, the court must decide on the operations of each. Thank you, Chief Justice John Marshall. So what happens here for the significance? Marshall really brilliantly walked a political tightrope. He avoided the potential embarrassment of having the court's ruling ignored by the executive branch because Thomas Jefferson didn't want to give that job to William Marbury. Thomas Jefferson was a Democratic Republican. William Marbury was a Federalist. Also, it expanded the power and prestige of the court. The court said to Congress, you did something that is unconstitutional and we're declaring it invalid. It also situates the court as more of a co-equal branch of the government by conferring upon itself the power of judicial review. Remember, Hamilton said that this branch would be the least dangerous branch, but now they're seeing themselves as more of equals. More on judicial review. The power of the Supreme Court and other courts to determine whether or not acts or actions of the government are constitutional. That's a good old definition of judicial review. This is not specifically granted or mentioned in the Constitution word for word. In this case, though, Marshall states that it's a power that is inherently held by the court. Other courts are able to do this, so the Supreme Court can as well. Furthermore, he declares that the courts have the final say on the meaning of the Constitution. So that's the last stop shop, essentially. So a couple similar cases, I've given you one in specifics, was McCullough versus Maryland. And I'm not going to talk too much about it because it's one of your 15 required cases, but there's some background information, okay? You've got to give background information and what the vote was and why they connect. If I cut off myself for the last slide, it's background information, what the vote was, and why they connect. And I've listed a few other similar cases because, guys, everything is similar to Marbury versus Madison because every case is SCOTUS using judicial review. So here's how you can remember Marbury versus Madison. Got a couple of memes for you there. And then here's I came up with this myself, guys, my way to remember it. So Marbury versus Madison, M&M. Which M&M is better? Is it Marbury chocolate or Madison peanut? Let's have the judges review. So Marbury chocolate or Madison peanut? Let's have the judges review. Get it? Judicial review? I know it's a stretch, but that's what you got to do. All right, guys, you email me if you have any questions. You know I'm always happy to get your emails.